Well, good evening to everyone on this exceptionally warm and sweltering day. Can I first of all thank Russell Dewhurst for undertaking the IT wizardry in getting this unusual meeting up and running. And as he has just demonstrated, if ever he has to leave the ministry, he has an assured job as a continuity announcer awaiting him just around the corner. This is the second of this year's Ecclesiastical Law Society Northern Province Lectures. We're indebted to Lizzie Wilson and her firm Wrigley's for devising this lecture series and for continuing to support the lecture series. And exceptionally, this evening, we're broadcasting by this live stream in an experimental way. But our speaker tonight is used to the exceptional and the extraordinary, because I well remember at her installation in Ripon Cathedral in February of 2018, I generally, as Chancellor, expect to be the centre of attention. It's something to do with the full bottom wig, the tights, the silver buckle shoes, and the knee breeches that have something to do with it. But on this occasion, I was completely outclassed and outplayed by a contingent of Maoris from New Zealand who entered the rear of the cathedral and shouted the most terrifying haka as if they were about to start playing international rugby. This was so surprising and so terrifying that for one brief second, Archbishop Sentamu was struck down into silence. It was wonderful that New Zealand was visibly present and audibly present, because that was where Helen-Ann had previously been exercising her ministry. But what stays in my mind particularly is the blood-curdling threat that these people issued at the end of their piece, when they simply said to us, "We must look after Helen-Ann." And the threat was, if we didn't, they would come back and reclaim her. Well, the fact that she is still in ministry is testament either to the strength of that threat or to the genuine warm and welcoming nature of the community in Yorkshire, which she is serving. Bishop Helen-Ann Hartley is a fourth generation cleric. She trained for ordination at Ripon College, Cuddesdon, and was ordained and served her title in the Oxford Diocese. She rejoined Cuddesdon as a member of the teaching staff before, in 2011, being appointed as one of the co-deans of St John's College in Auckland. In 2013, she was elected as Bishop of Waikato, if I pronounce that correctly, doubtless I'll be corrected, and served as Bishop of that large New Zealand diocese, until in 2018, she was reclaimed and brought home to start her ministry as the suffragan Bishop of Ripon in the still newly formed Diocese of Leeds. So we're delighted, Helen-Ann, that although physically you're not with us, we can see you already, and you will be giving your presentation this evening on law and life in the Anglican Communion. It's an extreme kindness you do us by giving this lecture, doubly so doing it in these extenuating circumstances. So could I ask our vast virtual audience to give a huge welcome to Bishop Helen-Ann Hartley.
Well, thank you very much indeed, Mark. I'm just going to share my screen so that I can get going. Hopefully you can all see that. Maybe Russell could give me a thumbs up just to confirm. Excellent, that's very good news. Mark, thank you so much for both for your invitation to give this lecture and for your very warm welcome. It is indeed a very hot and humid day. And it is a shame that we can't be together physically, but it's very good that we are joining in this online format. I've preached my first sermon down the telephone in recent months, and this is but my second lecture actually delivered online. So it's really good to be able to connect with you in this way. This afternoon, as it happens, I was participating in some Episcopal training online. And one of the things we had to do in a small group was to share something of what they describe as our origin story. In other words, where have you come from and what has shaped you to be the leader that you are today? And I found myself, because I'd been preparing this lecture, revisiting aspects of what it meant to become a bishop, which was an altogether unexpected experience in New Zealand. Bishops in New Zealand are elected rather than appointed. And so one agrees to one's name going forward into an election system. And that was a very interesting experience, to say the least. But it's interesting from a point of difference to voice that from the get-go. Now, it goes without saying, but I'll say it anyway, I'm not a legal professional, and I don't know whether it's more or less intimidating delivering a lecture to an audience I mostly cannot see. Indeed, one is often tempted in online situations to ask that searching question, is anybody out there? So for whatever reason you are zooming into this lecture today, and whatever your specialism happens to be, I hope you might find something in the reflections that I'll share with you just now, perhaps to make you think, to agree or disagree with, to ponder, or to reflect on in the coming days. Now, this is a lecture, of course, and not a sermon, but I am going to begin with a prayer from the New Zealand Prayer Book, because it's interesting that the New Zealand Prayer Book has a prayer in it for the judiciary and police. God of truth and justice, we ask you to help the men and women who administer and police our laws. Grant them insight, courage and compassion. Protect them from corruption and arrogance, and grant that we, whom they seek to serve, may give them the support and affection they need. So may our people be strengthened more and more in respect and concern for one another. Well, when your chairman, our diocesan chancellor, Mark Hill, invited me to give this lecture, he gave me what I'm calling structured free rein in choosing a topic. And he suggested, quite rightly, I think, that I might want to explore something about law and life in the Anglican Communion, which seemed to me actually to be as good a title as any, and one less thing that I had to come up with myself. Now, the Anglican Communion, of course, consists of 40 provinces and 5 extra-provincial areas across the entirety, or pretty much the entirety of the world. And I reflected that any attempt to cover the span of the globe in one lecture alone was probably not wise. And so I've opted, as you probably have guessed, to speak about a context I know relatively well: the Anglican Church in Aotearoa, New Zealand and Polynesia, where I served for just over 4 years as a bishop. And during that time, I got to know the province rather well, or rather the non-province, because Anglicans in Aotearoa, New Zealand and Polynesia don't necessarily like to call themselves a province. In this lecture, I will begin by exploring something of the background to being part of a worldwide communion of churches, which will include a light touch drop-in on aspects of Anglican history and polity, a gaze backwards to the witness of Scripture, and then examine broadly what authority might mean in a communion context. And I say might mean because invariably this is my take on what I think is an eternally complex topic. I do that to set up the basis of what I will then go on to discuss. I will outline something of the structure of the Anglican Church in Aotearoa, New Zealand and Polynesia, whereupon it will become apparent why one always has to use that threefold descriptor. And I will go on to focus on the relationship between law and a Maori term, tikanga. I'll need to say something about this in a broadly general legal context first, as well as discussing it with respect to ecclesiastical law. I think that such a discussion offers a fascinating case study that enables us to consider the complexities of law and culture and how ecclesiastical structures try to navigate multiple civil legal jurisdictions in attending to undertake the business of the kingdom of God. And I would say at the outset, if your head isn't hurting a little bit by the end of this lecture, then I probably won't have done my job. There's a phrase I've come across on a number of occasions about the learning that comes from living away from your home context and then returning, whereupon you view that home context in a fresh light. Sometimes I think in the Church of England, we forget that we are part of a worldwide communion. The Church in Wales, the Scottish Episcopal Church, and the Church of Ireland are all our immediate neighbours, for example. And you may recall the dismay that was caused in 2016 when the Church of England and the Church of Scotland, Presbyterian Church, announced an ecumenical agreement, which came as something of a surprise to the Scottish Episcopal Church, who knew nothing about it. The majority, if not all, of the dioceses in the Church of England, of course, have multiple connections with dioceses in other parts of the communion. So perhaps we might say with regard to that example that the Church of England maybe ought to have known a little better. There are many ways to describe being Anglican, but the Lambeth Quadrilateral and its four-point articulation of Anglican identity, adopted by the Third Lambeth Conference in 1888, is as good a place to start as any. At this point, I need to reassure you that I am not attempting to place your chairman as a fifth aspect of the quadrilateral, thereby turning it into an Anglican pentagon. The reason for displaying his image will become clear shortly, but I dare say he might rejoice at being in the screen company of both Richard Hooker and Thomas Cranmer. You may want to say a word about that afterwards. Back to our quadrilateral for a moment. The point of it in simple terms is to map out the parameters by which, as a worldwide church, Anglicans have a different understanding of authority compared with, for example, the Roman Catholic Church. The point hardly needs making, but it bears repeating here. New Zealand art critic Justin Payton once said that sometimes you find the map you need only after the journey has ended. However, which will likely apply to the majority of folk who may not have Anglican history at their fingertips all of the time. In the 16th century, Richard Hooker famously introduced the idea of via media with his three-legged stool of scripture, reason and tradition, sometimes misquoted as scripture, tradition and reason. For both Hooker and before him Cranmer, reason is the graced hinge that enables scripture and tradition to be understood with the mind. Cranmer, in fact, does speak about scripture, tradition and reason, but perhaps it's fair to say that he had a less optimistic view of human nature than Hooker. Either way, Anglicanism holds this trilogy in a significant and distinctive way. It is at the heart of what it means to be Anglican. Now, some now, and actually one of the bishops in my gathering earlier voiced this, some now want to add experience into the threefold mix. But I think that caution is needed here because experience is a very general term. I'm with Sam Wells when he says, experience is simply another name for the interpretative processes by which the Church comes to receive revelation from scripture, tradition, and reason. And I'm not sure if his order at this point was deliberate or not. Going further back, the early Church of the New Testament was much exercised by law in the debates about how to include Gentiles into what was originally a Jewish Christian movement. In Torah, better understood perhaps not so much as law as loving guidance or instruction in its acceptance of its authority, we have both ceremonial and moral law. For the early church, it was the moral law that was key to acceptance and its guidance for Christian life. The early church and its key thinkers, particularly the Apostle Paul, argued that circumcision and dietary laws under ceremonial law were not required for Gentiles. This view, of course, eventually won out, but was not accepted without a good deal of conflict. Unfortunately, the publication, The Principles of Canon Law, common to the Anglican Communion, does not come with a jazzy front cover for me to display on your screen. So instead, here we have a photo of our chairman, Mark, who in his 2017 chairman's report to the Ecclesiastical Law Society cited as having been described by the primates meeting this particular publication as perhaps constituting the fifth instrument of unity for the communion. When relations are fractured and communion impaired, agreed principles of canon law around which every province can gather may prove a welcome source of stability and insight in a fragile world. Any agreed principles sit alongside the so-called instruments of communion referred to in that quote from Mark Hill just shared. Of relevance to my topic today was the theme, indeed, of that 2017 conference, the nature and diversity of authority in Anglicanism. In a lecture delivered to the conference, Canon Phil Groves cited Archbishop Rowan's final address to the communion, where he commended corrective authority and the work of canon lawyers, but also recognised the difficulty of finding any point of authority from what was then a communion of 38 autonomous churches. Groves's lecture goes on to discuss the relative merits of the empowering authority laid out by Jesus in the Gospels. Archbishop Rowan's successor, Archbishop Justin, also quoted in Groves's lecture, describes conflict which arises from diversity. Archbishop Justin quotes the Quaker Faith and Practice book, which says, "By their silence, the progress of world peace has stood still. There is a need to name issues, to listen and let go of fear." End of quote, and perhaps rather pertinent to our current national and global life. Canon Groves also discusses the partnership model of the Anglican Communion, first laid out in 1963, and which failed because the models of partnership, if one can indeed call them that, were not resilient enough to hold fragile bonds together. The 2008 Lambeth Conference saw the arrival of the Endaba process of conversation and listening, and elements of that have continued in other forms, most noticeably in the continued discussions on the topic of human sexuality in the Church of England, the Living in Love and Faith process, which is ongoing. Groves also points to the adoption by the 2017 Primates of Oceania meeting of a process called Talanoa, although Groves incorrectly assigns this to a Samoan origin, when in fact it is properly more broadly a shared concept in Pacific communities. And what is Talanoa? Well, in its purest form, it is a process of talking about something, and in the talking, you find resolution. But that might take days, months, or indeed years, or, to Western ears at least, eternity. In one sense, I think ultimately Groves's views of communion complexity and resolutions of conflict are glanced through rose-tinted spectacles, though he is well-meaning in his attempt to map out what empowering authority might mean for the communion as a whole. When you've been around the proverbial block a bit, you become somewhat hard-nosed to how to hold difference in a way that is realistic and somehow enabling, even if it doesn't appear to be that at first glance. Furthermore, if it means fracture, then I think we have to learn to accept that and move on, with a hope, at least, that by God's grace, fractures can, in time, be healed, remembering that God's time is not the same as our time. The history of the Anglican Church in Aotearoa, New Zealand and Polynesia begins with the arrival of Christian missionaries, in this case, Church Missionary Society cleric Samuel Marsden, who arrived in the far north of New Zealand's North Island on his boat, the Active, and who preached a sermon on Christmas Day 1814 at Oihi Bay, and which was translated by Marsden's companion and Maori chief, Ruatara. The discomfort of colonialism marks a key aspect of this example of first contact between an Englishman and the indigenous peoples of Aotearoa, the Maori name for New Zealand, meaning long white cloud. You can't escape Marsden's belief that Christianity was the means by which the natives, as he called them in his journal, could be civilized. Marsden's aim was also to make peace in the aftermath of the massacre of the English crew of the ship the Boyd, which had taken place a few years earlier in 1809. Marsden also brought horses and cows to Aotearoa, New Zealand, and I often use this fact in conversation with rather hardened secular farmers in New Zealand. Did you know, I would say to them, that Anglicans brought dairy cows to these shores? That certainly gave them something to think about. As a National Geographic article notes, with regard to that sermon on Christmas Day 1814, none of the participants could have had any idea of what would unfold over the next 2 centuries. And it would appear that on that Sunday morning, Christmas Day fell on a Sunday in 1814, the future to many seemed bright. The photo on the right-hand side of your screen was taken by me in December 2014, during the commemorations of the 200th anniversary of Marsden's sermon. A cross is erected at the site where Marsden is said to have preached that sermon. As you can see, it was a bright, sunny day, the height of the Southern Hemisphere summer. One of my most frequently experienced emotions while undertaking episcopal ministry in Aotearoa, New Zealand, was the sense of the presentness of history. And I'll say a little more about that later. Perhaps we ought to append a question mark to the end of that Lucan quote. Was it really glad tidings of great joy that Marsden brought on Christmas Day 1814? Following the initial contact between Marsden and Maori in the far north, and bear in mind that Marsden arrived with a Maori chief and had an already established relationship with him. But following that initial contact, missionary activity grew and spread across the country. And this was largely, if not exclusively, driven by CMS, Church Missionary Society missionaries, who from 1823 onwards were led by the persistent energy of the Revd Henry Williams, who you can see on the top left-hand side of that picture montage. Williams undertook the highly significant translation of the Treaty of Waitangi into Maori in 1840. And I will say a little more about that treaty shortly, because it is probably the most important document in Aotearoa, New Zealand to this day. After 1840, there was a growth in more organised European settlement, mostly from England and Scotland, and the settlers perhaps naturally wanted their own settler church as they were familiar with it. In 1842, George Augustus Selwyn, you can see on the top right-hand side of your screen, arrived as Bishop of New Zealand, a bishop of what was then known as the United Church of England and Ireland. One important difference in the settler church was its non-established nature. In his address to the first gathering of the New Zealand General Synod on March the 8th, 1859, Selwyn said, do we then boast ourselves against our mother church in thus abandoning some parts of her present system? On the contrary, we desire as faithful children to show, so far as God may give us grace, how glorious she might have been in the purity of her doctrines and in the holiness of her liturgy, if she had been released from those chains from which the peculiar circumstances of the colonial church have set us free. The abuses of private patronage, the sale of spiritual offices, inequality of incomes, the failure of all corrective discipline over the beneficed clergy, the heart-rending injustice of dilapidations, all springing from the same root of private property, these are no part of the Church of England, and they must have no place here. We should be guilty indeed if, with our eyes open and a free choice before us, we should engraft upon our new branch of the Church of England the same abuses against which the preachers at Paul's Cross and Whitehall remonstrated in vain. The settlers placed great value on the liturgy of the Book of Common Prayer, or for Maori, Te Rawiri, which is the name David, as in the patriarch David. And to this day, the Book of Common Prayer, Te Rawiri, is highly esteemed amongst Maori and is used regularly. Now, 2 years prior to that speech by Selwyn, a general conference in Auckland in 1857 created the Diocese of Christchurch, Waiapu, Wellington and Nelson. Later in 1868, the Diocese of Auckland came into being. And from that episcopal see in 1925, the Diocese of Waikato was created. And I became the 7th Bishop of Waikato in 2014. That diocese was in fact reconfigured as the Diocese of Waikato and Taranaki in 2010, formalising a process many years previous when a portion of Wellington Diocese was let go of. It must be said that attitudes to diocesan reorganisation are perhaps typically pragmatic, evoking what is very much a Kiwi can-do approach. It's not done lightly, of course, and bears in mind history and geography, but it happens with due process. One of the further aspects of the shape of the church was that from Selwyn's time, the islands of the South Pacific were included in the provincial arrangement. Due to a map drawing error in London, the Solomon Islands was initially added to Selwyn's diocese, but Melanesia became a separate province in 1975. Having been an associated missionary diocese from 1925, the Diocese of Polynesia was created in 1990, consisting principally of Fiji, Tonga, and Western Samoa. Throughout this time, the New Zealand Church developed its own liturgies, which better reflected its Southern Hemisphere context, and its prayer book, that I quoted from earlier, was published in 1989. The Church as a whole developed a reputation for social justice and progressive moves, such as the ordination of women in 1977, and the first female diocesan bishop in the Anglican Communion, Penny Jameson, who became Bishop of Dunedin in 1990. It would be wrong of me to pretend that all of this was sweetness and light, because Bishop Penny, in particular, suffered greatly with prejudice of those who did not think that women could be ordained to the episcopate, and in many ways she bears the scars of that journey to this day. While we're beginning to get a sense of the geographical and lived context of the Anglican Church in New Zealand, certainly for most of its life it has retained strong links to the Church of England. In an article published in the Journal of Anglican Studies in 2010, Noel Cox describes the Church in New Zealand as being quasi-established, in the sense that whilst having the status of a contractual society, there are close links between church and state. The authority of internal church law rests, at least in part, upon the existence of secular legislation. And secular legislation expressly and directly regulates some of the temporal affairs of the church. The basis of this is the 1928 Church of England Empowering Act, which governs the alternation of the formularies of the church, its trust property, its former missionary diocese, and its clergy pension funds. Now, the reality is that while the secular courts would enforce the constitution and rules, they would be reluctant to intervene in church matters. However, the church is not exempt from regulation by general legislation, and thus it is illegal to discriminate on the basis of gender. There is no exemption from any Equality Act, unlike the Church of England. Though it must be said, of course, that the Equality Act in its exemption clauses applies to more than just the Church of England. In New Zealand, there are some statutory provisions made for ministers of religion, and that they are prohibited by statute from disclosing in any proceeding a confession that was made to the minister, except with the consent of the person who made the confession. However, any communication made for criminal purposes is not privileged. The offence of blasphemy remains in the Crimes Act of 1961. However, the law is confined to published matter, unlike England. There is a tension in this quasi-established status, in that the state can be militantly secular and post-Christian. And I think that the interdependent nature of the relationship hasn't always been beneficial either to the church or indeed to the growth of the kingdom of God. If you want a worked example of the potential toxicity of that interdependence, you need look no further than the aftermath of the Canterbury Earthquakes, following the 2011 quake which destroyed Christchurch's Anglican Cathedral, a picture that you can see on the bottom of your screen. Now, the quake actually destroyed both Anglican and Roman Catholic cathedrals, but all the fallout was focused on the Anglican Cathedral, largely due to its central prominent location in the city and the subsequent tussle between the diocese, which at the time wanted to rebuild with something new and missional in design, and crucially, earthquake-proof, whereas many in the city wanted it back exactly as it had been before, brick by brick. The government, largely not understanding the work of growing God's kingdom, tended to side with the secularists, and years of legal battles ensued. That has now been largely settled, with a very high cost, both personally to some and financially, and the decision was reached to rebuild as before, but with an assurance of earthquake-proof standards. Now, at this point, I ought to start referring to the Anglican Church in New Zealand as the Anglican Church in Aotearoa, New Zealand in Polynesia, and to give it its full title by adding the Maori, Te Hahi Mihinari ki Aotearoa, ki Nui, Tireni, ki ngā Mauteri o Te Moana, Nui a Kiwa. Perhaps the greatest development in the last 30 years has been the growth of bicultural partnership, which resulted in the revised constitution of 1992, giving equal status to Maori, Pākehā, which is the Maori word for other and used to designate European New Zealanders, and Polynesia. So that's a bicultural relationship with 3 partners. Given what I have described above about the distinctive Church of England nature of the Anglican Church in New Zealand, you won't be altogether surprised to learn about its long-held journey to inhabit its own bicultural context and history. The foundation for this may be seen in the 1840 Treaty of Waitangi, which I've already mentioned. The Treaty of Waitangi in 1840 was an agreement between representatives of the British Crown and more than 500 Maori chiefs, and it resulted in the declaration of British sovereignty over New Zealand by Governor William Hobson in May 1840. Most chiefs signed a Maori language version of the treaty. However, the English and Maori language versions held different meanings, which created different expectations. The resolution of those differences has echoed down the decades to this day. The immediate decades following the signing of the treaty were characterised by fierce fighting over land and the growth of movements of resistance, most notably the Maori King movement in the Waikato region. The first Maori king was crowned in 1858, Por Tātou Te Wherowhero, who hoped that his people would work cooperatively with the crown and that his people would, and I quote, hold fast to love, to the law, and to faith in God. The church was intimately bound up with the discord during these decades, sometimes for good, sometimes for not. My point is that the legacy of the relationship is very much living history. So when a British woman was elected Bishop of Waikato in 2014, it led to some interesting dynamics. Overwhelmingly, I was welcomed by Maori. It was very hard going at times. But when I was invited to give a speech in Maori at a gathering at which the current Maori king was present, I knew and felt the benefit of the bearing witness of relationships. I could certainly not atone for the collective sins of my British ancestors, but I could acknowledge the wisdom of the Maori saying, ka mua, ka muri, walking backwards into the future. The final thread of this tapestry came in the revised constitution of the Anglican Church in 1992 and the establishment under that constitution of the working of the General Synod Te Hinota Whanui. The Constitution of 1992 provided an opportunity for the three partners, Maori, Pākehā and Polynesia, to express their mind as an equal partner in the decision-making processes of the Synod. While the 7 New Zealand dioceses remained, along with the Diocese of Polynesia, 5 Maori dioceses, or Hui Amarangi, a phrase that means gathering of the people, 5 Maori dioceses were established, along with 4 bishops to assist the work of the Maori Bishop of Aotearoa. So if you can imagine a map of New Zealand and the Pacific Islands, there is 1 Diocese of Polynesia which covers all of that area, 7 New Zealand dioceses, 4 in the North Island and 3 in the South Island, and 5 Maori dioceses overlapping the 7 other dioceses. I think I said something about your head maybe hurting by the end of this lecture. At this point, I want to introduce us briefly to this book by David Hackett Fisher, published in 2012. Fisher is Professor of History at Brandeis University in the United States. In this book, he sets out to compare New Zealand and the United States, 2 open societies. While they share elements in common, they are differentiated by an emphasis upon freedom as the ultimate goal in the United States and fairness as the ultimate goal in New Zealand. Both, of course, New Zealand and the United States were founded by English-speaking colonists, but with quite different results, not least in the role and place of their indigenous peoples. Fisher is fascinated with how these 2 societies developed and the lasting legacy of their development today. Now, this book was written in 2012, and it would be interesting to discuss its contents with its author today, given the current state of both US and New Zealand politics, not least in their respective leaders. Leaving aside the obvious differences of scale, geography and population size in particular, and the timings in terms of the history of the development of these nations, Fisher maps out a line of argument that resonates today, perhaps because it invites us to wrestle with that oft-quoted phrase, British values. In his conclusion, Fisher writes, Americans think of an open society as a free society, centred primarily on the values of liberty and freedom that are deeply rooted in American history. New Zealanders are more mindful of fairness, justice and equity, which have long been an important part of their experience. Other cultures are much concerned with equality in its many meanings: equality before the law, equality of social status, equality of material condition, equality of opportunity, and equality of esteem. Regarding fairness, Fisher describes how it was a concept unique to English, Norse, and Scandinavian languages, and defines it as not taking undue advantage of other people. He argues that Kiwis of all political persuasions have embraced fairness, even if they disagree on how it is best achieved. It is noticeable how New Zealanders laud heroes of sport, war, and mountaineering for their decency towards others. This is brilliantly laid out in James Kerr's 2013 book, Legacy, where he examines the success of the All Blacks rugby team and how the language and culture of fairness and the character of humility has been a key factor in their ability and capacity as a team. Fisher further gives the example in New Zealand where everyone is insured against accidents, regardless of fault or cause, and is taxed too, to pay for it, depending on the danger of their profession. I'm not sure where lawyers or clergy are on that scale. There is therefore a different working out of the principles and operations of tort law, for example. The insights of this book are helpful, I think, in enabling us to understand something of the dynamics of the New Zealand culture. It is in many ways a very flat society. While humility is seen as important, it can be debilitating when the so-called tall poppy syndrome is at play, and achievement and success are seen as chipping away at values of equality, unless, of course, we were talking about rugby. We have examined aspects of the history of the Anglican Church in Aotearoa, New Zealand and Polynesia, and of the New Zealand culture, and have observed the presentness of its history. Law and life are inextricably woven in and shaped by that culture, both secular and ecclesiastical, and even they, in some way, are intertwined. Before I conclude, I want to examine one more aspect of culture which impacts upon law and life, and that is the Maori word tikanga, and it is that I now briefly turn. In the 1992 revised constitution of the Anglican Church in Aotearoa, New Zealand and Polynesia, the three partners are referred to by the Maori word tikanga, tikanga Maori, tikanga Polynesia, tikanga Pakeha. Tikanga is a word that means the correct way of doing things, or convention or protocol. Crucially, these are the customary system of values and practices that have developed over time and are deeply embedded in the social context. The word that often comes before tikanga is kawa, which are the customs and protocol laid out. So one way of describing this is to say, kawa is what we do, and tikanga is how we do it. At all times, it is essential that the mana of a person, a place, or an entity, such as a river and a mountain, and here it is worth noting that in 2017, a river in the North Island of New Zealand, the Whanganui River, was granted legal personhood. In 2014, the Urawira Park was recognised as a legal person, and in 2018, Mount Taranaki was awarded the same status. Anything that happens on, in, or around these places must ensure that their mana is intact. Mana may be defined as an absolute and enduring authority that is expressed in many forms, imbuing the holder, either animate or inanimate, land or person, for example, with a divine presence and locatedness. In her 2007 article in the Yearbook of New Zealand Jurisprudence, Linda Te Aho, Associate Professor of Law at the University of Waikato, writes, Tangata Whenua, meaning people of the land, that is Maori, Tangata Whenua system of law and government existed before colonisation by the British. Tikanga Maori and Maori customary law are terms, not necessarily interchangeable, that embody the values, standards, principles or norms that Indigenous Maori have developed to govern themselves. There are a number of articles that assert Tikanga Maori as the first law of Aotearoa, New Zealand. She continues, although not recognised as such by the colonisers' judicial institutions initially, the courts have, for better or worse, incorporated tikanga into the common law of New Zealand. The instances of its use, however, are limited because of the predominantly codified nature of New Zealand law and the ideal of parliamentary supremacy. The role of tikanga Maori is most evident in the Maori Land Court, in the interpretation and application of legislation relating to Maori law land. A further significance is Te Aho's observation that appropriate conduct in terms of tikanga varies from tribe to tribe and is dynamic rather than fixed. Yet many Maori would agree on a common set of core values that determine appropriate conduct. In particular, whakapapa and whanaungatanga, the importance of genealogy, of connections to land, to creation and to each other, mana, already referred to, utu, reciprocity, tapu and noa, sacredness and secularity, and kaitiakitanga, stewardship. She cites the continuing customary practice of rahui, a prohibition on the use of a resource, as an example of tikanga in action. When the recent White Island volcanic explosion took place in the North Island, or just off the North Island, and a number of people were killed, local Maori placed a rahui on both the island itself and the fishing waters around it, meaning that no one could enter or fish from that area. From an historical perspective, Te Aho points out that Aotearoa was colonised when legal positivism dominated European thinking in the 18th and 19th centuries, and so custom was not considered to be law. A certain amount of struggling with the notion of Maori customary law, and remember the terms tikanga Maori and Maori customary law are considered often interchangeable. A struggle with this may be seen in a number of later 19th century cases regarding land. In the 1877 Wi Parata versus Octavius Hadfield, Bishop of Wellington, the judge Sir James Prendergast, seen here on your screen, ruled the Treaty of Waitangi as being worthless. And this had significant impact on many subsequent rulings, which justified the alienation of Maori land. Prendergast had found that Maori had not a settled system of law, and an act referring to the ancient custom of Maori, in this case with respect to land, in his words, cannot call what is non-existent into being. As I approach the conclusion of this lecture, I want to give you a couple of brief examples as to how tikanga works in church life, and in particular at the General Synod Te Hinota Whanui. Usual Maori tikanga on a marae, which is the name given to the complex of buildings where business is conducted and often worship takes place, is that there are two sides, a side of rows of seating for the members of that marae, the tangata whenua, a phrase we have already encountered, which means people of the land, and a side of rows opposite for the visitors, known as the manuhiri. Normal custom is for men alone to sit on the front row of seating, because men alone do the speaking on a marae. Women are required to sit behind, and their power, for want of a better word, is to support a speech by a man by singing. And I do use that word power because if it is considered that the speech is either inappropriate or going on for too long, the women can stand up and sing, and that will end the speech. I like to try that sometimes in church contexts. And that doesn't happen very often, but I have seen it happen, and it's quite interesting. As the Anglican Church in Aotearoa, New Zealand and Polynesia had, when I was bishop, two female bishops, myself and Bishop Victoria Matthews, the Bishop of Christchurch, pictured here on your screen, an issue arose of our male Episcopal colleagues being given seats of prominence, and myself and Bishop Victoria often having to sit behind them. It was, after considerable discussion, deemed right that in fact Bishop Victoria and I should actually sit on the front row with our male colleagues. But this was not without its challenges. As I have already said, tikanga is dynamic. And at the commencement of the 2014 General Synod, at the opening ceremony which took place at the Upper Marae at Waitangi, so exactly where the treaty had been signed in 1840, the ceremony being a formal process in Māori as a porphyry to welcome and start the synod, this church tikanga of equality was challenged on the floor of the marae, and Bishop Victoria and I had to get up and move to the row behind our male colleagues. There was considerable fallout from that. The second example, finally, I want to share relates to how resolution is reached without recourse, often to canons, first and foremost. In other words, the canons sit alongside conversation and are there if required, but do not necessarily drive the parameters of a discussion or a process. And the example relates to how the discussion and debate around human sexuality was finally resolved, or at least taken as far as it could be, in 2018. I left at the end of 2017, and was actively part of the process of its discussion at both the 2014 and 2016 General Synods. The resolution was that it is permitted for clergy to conduct blessings of those who are in same-sex marriages, but that this permission was and is devolved to a diocesan bishop. This resolution, crucially, does not apply to the Diocese of Polynesia, because the Diocese of Polynesia contains jurisdictions where same-sex activity remains criminalised: Tonga, Samoa, and the Cook Islands, where the Diocese of Polynesia is concerned. While many in the Anglican Church wanted same-sex marriage in New Zealand, because it is allowed by civil law, that simply was not possible because of the context of multiple jurisdictions. When General Synod Te Hinota Whanui met in Nandi in Fiji in 2012, a synod at which I was an observer, all synodical discussions on the topic of human sexuality were conducted with police present, who were listening to what was being said. Same-sex marriage remains illegal in Fiji, though there are legal protections around discrimination. The Diocese of Polynesia's view on the ongoing discussions was that this was for them an example of talanoa, a word we encountered earlier in this lecture, and which means simply ongoing discussion, which may or may not be resolved. Tikanga Maori viewed the issue of same-sex relationships as culturally challenging, but resolvable in their understanding of same-sex relationships as a matter of justice. Tikanga Pākehā had no single view on the matter and were in disagreement, hence the eventual outcome of devolved decision-making, which most, but not all, could live with. On the floor of General Synod, anyone can stand up and call for a caucus, which suspends General Synod and requires each tikanga to hold their conversations and then to send emissaries to represent a viewpoint which may or may not then enable the whole to come back together again. Decisions are made then, where possible, by this delicate and at times frustrating mode of conversation, listening and reflection, which requires that issues are dealt with face to face rather than parked for someone else to deal with, or by forced implementation of an aspect of canon law, for example. But it can be a long, drawn-out process, which can wreak havoc on carefully drawn-up synod timetables and programmes. Conclusions. I've nearly reached the end of our exploration of law and life in the Anglican Communion, with particular reference to the Anglican Church in Aotearoa, New Zealand and Polynesia. What conclusions can be drawn? In a sense, I hope we can tease these out in the Q&A to follow shortly. But I want to take us back to something I said at the start of the lecture about the formation of the early church. I said this: going further back, the early church of the New Testament was much exercised by law in the debates about how to include Gentiles into what was originally a Jewish Christian movement. In Torah, better understood not so much as law as loving guidance or instruction, in its acceptance of authority, we have both ceremonial and moral law. For the early church, it was the moral law that was key to acceptance and its guidance for Christian life. The early church and its key thinkers argued that aspects of this ceremonial law were not required for Gentiles. This view eventually won out, but was not accepted without conflict. The life of the Anglican Church in Aotearoa, New Zealand and Polynesia is an example, I think, of a church forming, storming and norming, to quote Bruce Tuckman's Stages of Group Development, which I think is what we see in the Book of Acts and in the Pauline letters, perhaps themselves in written form, the very first version of Zoom. The fourth stage of that group development model is performing, and that is where I place the dynamic tension of tikanga and law. You may find it ironic or even culturally questionable that I should be using a model that comes from a United States psychological researcher in the 1960s to reflect on law and life in the Anglican Communion. But I do so with the challenge of Tuckman's final stage in group development, adjourning, with a warning and a hope that despite the many differences the Anglican Communion faces, it will remain, and that the Anglican Church in Aotearoa, New Zealand and Polynesia provides a lived example of resilience and persistence in the pursuit of the kingdom of God. So perhaps most appropriately, I end with a Maori quote. Waiho kia pātai ana, e kaha ui te kaha. Let the questioning continue. The ability of the person is in asking questions. Thank you very much.
Well, Bishop Helen-Ann, I'm sure I speak on behalf of the many listeners and viewers in expressing gratitude to you for that presentation. And I noted in the course of you speaking that the range of those tuning in encompasses both Norway and Canada. So this isn't an entirely domestic audience that you have been lecturing this evening. But it's important you get a moment to catch your breath, to take even a glass of water as well, because fascinating insight, reflective of your experience, living with and leading the Anglican community in a very different part of the Anglican Communion. Curiously, I can't pretend for a moment that the chat box was fizzing as you were speaking. But I think the reason why people were not sidelined into typing questions was because they were also heavily engaged in what you had to say, which was extremely interesting, as I'm sure it opened what for many people was a completely new area where we knew very little at all. There's a question that's just come in now, which I would like to take in a moment from Stephen Hoffmeyer, and perhaps Russell can do whatever is necessary to bring Stephen to the forefront. While that is happening, can I just remind you that there is the facility within Zoom to raise a hand within the system, which will allow your name and face to bubble to the top of the 60 or 70 people who are watching. And I can then take those questions one at a time. I think I will also exercise Chairman's prerogative by throwing in a couple of my own. Because I particularly enjoyed, Helen-Ann, as you might imagine, the magnificent PowerPoint slides, one of which I suspect will be my screensaver before too long. But Stephen, if you're ready to ask your question, can I go directly to you, please?
Thank you very much indeed, Mark, and may I add my most sincere thanks to you, Bishop, for an extremely insightful and helpful presentation. The ground you covered was remarkable, and thank you so much for that. Very, very helpful, lots of personal stories as well as history. Really very helpful, thank you. My question is a typically legal question, and I apologize for that, but it is, could you please tell us more about the precise constitutional rationale for the two overlapping jurisdictions on the North and South Islands, the 7 dioceses of the Church of New Zealand, as I understand it, and the 5 dioceses of the Maori Church?
Thank you very much, both for your kind words and for that question. The quick answer is, I recommend that you Google the 1992 Constitution and have a good delve into it. I think the point of it really was that because of the importance of the Treaty of Waitangi in the bicultural nature of New Zealand, and because in many ways the practice of government, of parliament, is very much treaty-based in giving equal voice to Maori and to Pakeha. And we need to remember that Maori, in a sense, only make up 14% roughly of the whole population. However, that treaty really is the sort of guiding light, if you like, in New Zealand culture. So the Anglican Church, given its intimate involvement, particularly in the history, both of the treaty and what happened in the run-up to and afterwards, felt that it wanted to do its bit to be as treaty-like as possible in its structure. And therefore it came up with this time-bending resolution of the 7 New Zealand dioceses, but with overlapping Maori jurisdiction, which meant effectively the diocese where I was bishop overlapped with 2 Maori dioceses. And those bishops dealt primarily with their people, if you like, but a bishop is a bishop is a bishop. So, you know, working together collaboratively, you just had to work that out. And it wasn't always neat and tidy, but at least it was always traced back to that particularity of that treaty relationship. But you can access the Constitution online, so I encourage you to do that and have a look at how that's worked out in the detail, because I'm sure that would be worth doing.
I'm most grateful to you. Thank you.
There's a question in the chat room which has come from Andrew Burns. If Russell, you can bring Andrew forward, then I can invite him to put his question. I can't see any other hands going up, but that may be a fault with me using the system. So if there are others who want to follow after Andrew, it might be wise if you put a brief indication in the chat room, because I can then use that to give you the floor in due course. Andrew.
Thank you, thank you. One thing I should note before I ask my question is that I hadn't expected to see a TARDIS over your shoulder, and as you might see just over my shoulder here, that's one of the things that sometimes my clients spot in these Zoom calls, and they say, any more questions? I say at the end of the conference, they say, yes, why have you got a TARDIS on your shelf? So I might ask about the intergalactic travels of Bishop Helen-Ann, but my main question was really a bit less legal than Stephen, a bit more controversial, which is, what do you see in the English Church as the closest to that tension between law and custom tradition, Tiganga? What's the Tiganga equivalent in the English Church that now you've come back and you've experienced both?
Oh gosh, what a question. Well, I think because it was often talked about actually in the New Zealand context, the arrangement that the Church of England reached over the ordination of women, and particularly the ordination of women to the episcopate. However, the New Zealand take on that was vehemently, that is not tikanga, that is not how tikanga works, because what in their eyes that did is that it sort of obliterated their long-held search for equality and justice, which is kind of hardwired into Maori in particular. So you could view, as indeed sometimes in my head I view it, as tikanga, because it means you can coexist. However, in the correct meaning of that term, actually it's not tikanga. But where I see the tikanga dynamic currently is, I think, in the debates over human sexuality, which are ongoing in the Church of England and which are kind of gaining some momentum at this point. Where that will end up, I don't know. I think what the New Zealand Church demonstrates is that capacity to hold extreme diversity, not without cost, because some people did leave the Anglican Church in New Zealand when same-sex blessings were given church approval. But for the most part, I think there is a holding together that tikanga allows. So I hope that sort of answers your question. Thank you. And the TARDIS is definitely a positive fixture in my Zoom conversations. So I'm glad you've got one too.
I was about to say, if Andrew had any conception of the size of the Ripon Episcopal area, he would know exactly why you have a TARDIS so close at hand. There's a question, I think, from Ian Jorish, if I could bring him in, please, to ask his question. Ian.
Hello. Thank you ever so much.
And forgive me if I've mispronounced your name.
Not at all. I'm used to any pronunciation, I assure you. But
it's a very bad Scrabble hand.
Thank you ever so much, Bishop, for that. That's fascinating. I mean, my question, I think, is possibly similar to the one you've just answered. But what do you think the rest of the Anglican Communion and the Church of England in particular has most to learn from your former church down south?
I think it is in the very real way that the church has faced up to some of its difficult past, particularly its involvement in colonialism, and I think it's faced up to that because Maori have had that voice to be able to bring it up as an issue which must be confronted. So that's part of what I talked about, the sense of presentness of history, which I think particularly in our current context as church, with the whole Black Lives Matter awareness and consciousness in most recent weeks and days, there's something to be said for that phrase of walking backwards into the future, and how actually you deal with conflict and resolving that in a way that is painful, yes, but which somehow allows for listening, recognition, and a return to wholeness of something that has been quite fractured. So I think we've something that we can learn from that example.
Thank you.
Ashley Mitchell, I think there's a question coming from you, if we can reach out to you somewhere.
Yeah. Question I got is, recently the Church of England entered into shared conversations as a way of trying to engage in a way forward. Do you feel, which is quite unusual for the Church of England, do you feel that echoes and parallels some of the New Zealand approaches to discerning and deciding the way forward?
Hello, Ashley. Yes, it in many ways it does, although I think it would probably take its origin from the Indaba process more explicitly than a sort of tikanga by tikanga negotiation. I think where the interplay of tikanga in a New Zealand General Synod context differs slightly is that you've got an explicitness of different groups, different clear groups who are engaging in conversation about an issue, and who send emissaries between one group and another to try and come to resolution. And there's an awareness too that people will go hell's bells on the floor of synod, but after it you'll all share the sign of the peace and have a nice meal together. So there's something kind of hardwired into New Zealand Maori culture that holds all of that in a way that I don't think we quite got here. I'm not saying we couldn't have something like that, but I think there's a certain amount of risk and rawness to the tikanga process that you don't often get in the sort of politeness of shared conversations, for want of a better phrase.
Thank you.
I'm not aware of others desperate to get in, but perhaps I could throw in something from my point of view. I'm just wondering, Bishop, if you had a free hand and could introduce into the Church of England's proceedings some aspect of Maori customary law, or some aspect of the practice of the church from which you've come, what might it be?
I think it probably lies in, and maybe actually, we do this already. Perhaps we just take it for granted, that the sort of Maori process of the formality of welcome, of speeches, of singing, of sharing the peace, of food and laughter and celebration, which might all be wrapped around a funeral or a difficult issue, or simply joy at receiving a visitor. There's something in that process which is quite inspiring and quite wonderful in its attention to what it means to be in relationship with another person as a human being. And I think in many ways we do that here in the church. I've certainly experienced incredible hospitality in North Yorkshire. Maybe it's a North Yorkshire thing in terms of the quality of the after-service bun fight, etc. But I think there's something sort of held and acknowledged and deeply respectful of how Maori tikanga operates in its welcome and its holding of people and particular issues that we can learn from here.
Thank you very much. I overlooked, I'm sorry to say, an earlier question from Julie Baker, and I'm sorry about that. So, Julie, if you're still available, I'm sure the Bishop would love to hear from you. Julie.
Thank you, Mark. And thank you, Bishop Helen-Ann, for a fascinating lecture. My question was, if I remember something you said earlier on in your lecture correctly, you spoke with deep realism about recognising that fracturing does sometimes happen and maybe needs to be permitted to happen because through God's grace, healing can, in time, occur. And I just wondered how you felt, what that might look like for the wider Anglican Communion, given the difficult issues that we are continuing to deal with, particularly around human sexuality, and particularly for a people of God who prize unity very highly.
Hello, Julie. Thanks for that. Yes, when I referred to that fracture, I was thinking quite specifically of very early on when I became a bishop in New Zealand. Quite a prominent evangelical church in Hamilton, one of the big parishes in the diocese, decided to leave over the issue of the discussions of human sexuality, and so I found myself in a matter of weeks facing what became in New Zealand a sort of national news story. I mean, it's a different context, different size, but front cover of national newspapers, etc. This church was leaving, and it was a bit of a storm. And while it was very difficult at the time, and while in a sense that fracture continues, because indeed in New Zealand GAFCON have ordained a bishop in the South Island to look after a small number of parishes who call themselves Anglican but don't consider themselves to be part of the communion, at least in terms of what that means to be in communion with Canterbury particularly, or with one another. There's something I think that one has to hold out for in terms of the hope that could pull that back together. And I'm not naive around that, but it's simply something that over time, fractures can be healed, but that might not look like something that we would expect or necessarily even desire, but that nonetheless fractures, we have to expect that fractures will happen, and we have to be ready to find a way of dealing with that in a way that acknowledges the distress and the brokenness of that. Of course it falls short from the ideals of the kingdom of God, but which nonetheless allows that frailty of humanity to be held and realised.
Thank you. I think that's a deeply realistic answer, and I would entirely agree.
Thank you.
I think there's one questioner still waiting in the queue, and I will take him as the final question this evening, unless anyone is desperate to come up with a follow-up question of some sort. And I see somebody just has. So I'll take Ian Potter, then I'll take Matthew Chinnery, and then I will draw these proceedings to a close. So Ian Potter next, please.
Thank you. First of all, can I again thank the Bishop for a really interesting talk in an area which until today I knew very little about. So I'm grateful for you educating us. I was going to ask a question, and I don't know if it's a question with an answer, but from your experience as a bishop and your experience serving elsewhere in the communion, which is easier? To be a Church of England member of clergy moving to serve elsewhere in the communion, or to be a member of clergy from elsewhere moving to serve in England? And I say this knowing that in Sheffield I know a Brazilian missionary who serves in the church here, and I also know a Tasmanian a member of clergy who serves here, and both have found the interest and the experience to be interesting.
Oh gosh, well, I think I could answer that a number of ways. Some quick reflections. The Church of England was the church where I was ordained originally in 2005, and I went to New Zealand in 11, as Mark said, to teach in a theological college, and then found myself elected a bishop. So I think that process was difficult in the sense that in New Zealand bishops are elected, so you allow your name to go into an election process. You're not appointed. It's very open. And the downside of that was that when I was elected, there were 10 candidates in the election, 8 of whom were senior clergy in the diocese, and they decided to elect me. So in many ways, I was the complete outsider. So you can imagine what it's like arriving in a context as a bishop where you've got 8 people who would rather that they were the bishop and you weren't. So that was quite interesting and difficult, shall we say. Coming back into the Church of England after having had that communion experience, I think has, for me, been a wonderful gift and opportunity, both for me to really examine what it means for the Church of England to be the established church, having been in a context where the setup is quite different, and to navigate and look at some of the differences, and also the weight of history being very different in both contexts. So it's not been without its challenges, both in going to New Zealand and adjusting, and then coming back to New Zealand, from New Zealand to the Church of England, and then figuring out what it is to be a bishop and an area bishop in that context. But I think perhaps the New Zealand experience has left me with a rich understanding of what establishment is about, what do I think about that, and what does it mean to be a bishop in the midst of all of that. That's a really, really helpful question. Thank you.
Thank you.
And I said I'd give the final question to Matthew Chinnery. So, Matthew, the floor is yours for one last brief question.
Thank you very much, Chair, and thank you, Bishop. I was particularly interested in the descriptor of quasi-established. Coming from Wales, where we tend to use disestablished, but also regularly speak of the vestiges of establishment in relation to marriage and burial in particular. I'm intrigued if it's descriptors sort of historic interest only, or whether it's still an understanding that influences the work of the province, and if so, in what ways and how. Thank you.
Thank you. I think the phrase quasi-establishment I don't think is historic. I think it was an attempt in that particular article that I cited to deal with the fact that the Anglican Church in New Zealand is kind of based on this 1928 Church of England Empowering Act, which is always there whenever you're attending to church business. But I think because of the fact that the state would really rarely intervene, that it doesn't actually impact on a day-to-day basis, although it's always present. And it does kind of mean that in a number of what you might call state occasions, although the default would always be to Maori to provide spiritual guidance, but nonetheless there are a number of state occasions that I can think, for example, the funeral of former Governor-General Sir Paul Reeves, which took place in the Anglican Cathedral in Auckland. So there's a kind of looking to the Anglican Church because of its history and because of its involvement in and around the treaty years. But it's, you know, in and of itself, it kind of sits with this tikanga dynamic, which is both fluid and flexible, but which ultimately is tied up in this 1928 piece of legislation, which still exists. So it's in many ways, it's a thing that I often say to people, well, you kind of have to live it to sort of get how it works. It's difficult to describe, and maybe you can understand that with regard to your own context. But you know, that there is a tie-in to the secular legislative powers of the state, but the church itself, of course, does its business as it will do its business, and doesn't necessarily have a place of privilege, unlike the Church of England.
Well, this is a stage where, had we been meeting in the diocesan offices in Leeds, as was intended, I would invite everyone to step next door and enjoy a further glass of wine and a continued animated conversation and scurrilous gossip. Well, we can't do that, but I hope, Helen-Ann, somewhere near at hand you have a gin and tonic or a white wine on chill, which you can now enjoy, because you certainly very much deserve it. This was intended as an experimental exercise to see whether, as a small society, we could do live streaming to an audience which couldn't physically be gathered because of the COVID-19 difficulties. The trouble is, Bishop, if I may say so, you've made it look so easy that we're going to be encouraged to operate in this way time and time again in the future. So we are hugely grateful for your willingness to take part in this experiment. We're grateful to the technicians who've made it all work, to Russell Dewhurst, assisted by Anne-Marie Organ and Elizabeth Wilson. Please keep in touch via the Ecclesiastical Law Society with future events, which are likely to be virtual for some months still. And if by any remote chance anyone tuning into this lecture is not already a member of the Ecclesiastical Law Society, then I hope you will feel encouraged into signing up. You need only go into the website. It can be done electronically without any difficulty in a matter of moments, and I'm sure you won't regret it. But Bishop Helen-Ann, we are hugely in your debt for the time you've spent with us this evening, for taking us through with such clarity an area both geographically and conceptually about which we knew so little. And the further joy is for those unable to be part of this live stream event, it will be available shortly on YouTube, so it can reach an even wider global audience. So Bishop Helen-Ann, personally and on behalf of everyone here this evening, thank you very much indeed.
Thank you, Mark.